Are you Miss Molly Lerner?
Yes.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Right from the start, the judge wastes no time. 6 months in jail or thousands of dollars in fines. Imagine being Molly right now. The weight of those words hits harder than the walls of the courtroom itself. Jail means losing freedom, but money lingers. Debt follows you, crushes your family, wrecks your future. Judges know this psychological trick. Fear of financial ruin cuts deeper than fear of jail. So I'll ask you, what would shake you more? 6 months locked away, or years of debt dragging behind you?
On January 30th, 2025, officer ran checks on a vehicle in Harris County, Texas, without proof of financial responsibility. The vehicle also had a defective brake lamp. The traffic stop was initiated. Defendant driver, ID'd by Texas driver's license, stated she did not have insurance for the vehicle. Officer observed defendant to have thick
Bloodshot eyes or thick slurred speech.
Speech and the odor of marijuana emitting from inside the vehicle.
Officer asked defendant when she last smoked inside the vehicle. Defendant stated she had a few roaches inside the vehicle. Probable cause search was conducted. Officer found 0.103 ounces of marijuana. A DRE officer arrived on scene and conducted Romberg test. Defendant estimated passing of 30 seconds and 12 seconds. Shows D is in an elevated state. DRE also observed thick SS, FSTS conducted, 6.6 HGN, 3 out of 8 on walk and turn, 2 out of 4 on one-legged stand. When the defendant was arrested, D repeated the phrase, "Oh my God," several hundred times. Officer knows from ARIDE training that this is a symptom of dissociative anesthetic. The SC read, D refused to sample the breath, blood. Search warrant signed and executed.
Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Can you look to see if she has any prior DWIs? Number one. Number two, if she has a valid Texas driver license, please.
No prior DWIs.
Okay,
And your driver's license.
great. Okay. Ms. Lerner, like I said, no alcohol, no drugs. I'm going to randomly test you. Do you have the ability to hire a lawyer, or would you like a court-appointed lawyer? Okay, I need you to fill out an application for me. I'll take a look at it. And then for now, I'll also have you sign a receipt with Victoria. I'll later have you get with Fleischer for your bond conditions, and then I'll have you meet with a lawyer.
Is their license being suspended?
I'll let you talk to a lawyer about it. I can't give you legal advice.
Okay.
You know, assuming we give you a lawyer, you can ask the lawyer, and the lawyer can advise you properly.
But if it's not working, I lost my job.
Just, yeah, talk to the lawyer, and they'll be able to advise you properly. I haven't, as long as you have a valid Texas driver license, I'm not taking away your privilege to drive, okay? So, yeah, all right, let me have you get with everybody, and then we'll have you speak to someone here momentarily, okay? Please. Matthew Leonard.
Yes, sir.
So Leonard, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, on 4/12/2023, officers were dispatched.
Hey, yo, hey.
On 4/12/2023, officers were dispatched to a crash involving a bus and a car at the 1700 block of Travis Street. Officers made contact with the defendant who was slumped over in the driver's seat of the car. Officers observed the defendant to have red and glassy eyes, strong odor of alcohol in the breath, SS, and slurred speech and incoherent speech. The defendant told officers that he was drinking 211's beer at his house and last drank 2 hours ago. The defendant was taken to the hospital and diagnosed with a minor brain injury. Officers got a blood warrant. There was a blood draw completed at JPC.
Then, so what, do you have the results? Hold on a second, let me see.
No, not yet.
That number, .198, is staggering. For context, that's more than double the legal limit. At that point, your body isn't just impaired, it's malfunctioning. Reaction times slow, vision blurs, judgment disappears. You're not just a danger to yourself, you're a loaded weapon behind the wheel. Judges see this, and it changes the tone instantly. A .198 isn't an accident, it's a threat. And this is where public safety outweighs sympathy. The question is, should someone caught this high ever get a second chance at driving without restriction?
No, Judge, we don't have any blood results
I see
yet.
it.
For some reason, there haven't been any to-dos done on the case. I'll submit them immediately.
Well, it looks like it's because it was a 2B, that's why. So it's from April of 2023. Looks like there was a blood of a .198. Okay, Mr. Leonard, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. Because it's a second offense, I'm now ordering you as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it. Miss, can you run his license, see if he has a valid Texas driver license, please? Do you have the ability to hire a lawyer, sir?
How much time can I pass this? I'm in the process of getting my ID and everything, because when I got locked up, I didn't have my wallet. They threw it away or something.
Would you like a lawyer, sir? I can give you a lawyer today.
Yes, sir.
Okay? So understand something, Mr. Leonard. I don't want you drinking. I don't want you using illegal drugs. I'm going to randomly test you.
Yes, sir.
And you're going to have, do you show a Texas driver license?
That's all we do.
Okay. All right, sir. So what I'm going to have you do now is I'm going to have you sign a bunch of paperwork with Victoria, Fleischer, and then I'll have you meet with the lawyer here momentarily. Okay?
Yes, sir.
Please. All right. Good morning, Mr. Hunter. We're bringing you back because you now have a new fugitive case and you have a new lawyer. What would you like?
We're seeking fugitive bonds on these matters. The new matter, to the best of my knowledge, this from North Carolina, is basically the same complainants of the Houston case. Same folks. I think their surname is Beaker. I think a $30,000 bond has been set in the case here in Harris County. We would respectfully request bonds in the amount of $20,000 on the 3 fugitive warrants and let my client sort things out with those other jurisdictions as well as ours.
Honor, because of the fact that he has now 3 fugitive cases in our court, 2 out of Knox County, Tennessee, and now a new one out of North Carolina County, we'll be asking for no bond.
I told him beforehand, we visited this issue before, and I told him the last time that he was here that I wasn't going to give him one. He just got way too much baggage. And it's all the same thing where it's a theft from an elderly, and we have the same thing that's occurring over and over and over. You know, and it scares me that if we let him out, is he going to pick up a 5th case, you know? Or it just is so much baggage. He scares me, you know? And
He does have, he's kind of been a resident of this area, you know, for 25 years. So
I get it, but he's got a lot. He's hopscotching with the states as far as criminality, right? He's got 2 cases in North Carolina, or 2 in Tennessee, 1 in North Carolina. Now he has 1 here. He's got, in 3 different states, he's got charges. It's too much. And I think that because of that, he's a big flight risk, and I don't want to lose him.
Here's the twist. A couple of roaches turn into a mountain. 103 ounces of marijuana. That's no casual stash. That's distribution level weight. In the eyes of the law, that's the difference between reckless driver and drug dealer. It doesn't matter if Molly insists it wasn't for sale. The numbers speak louder than excuses. Prosecutors love numbers like this. Jurors hear them and immediately imagine an operation, not a mistake. And it makes you wonder, should someone's entire case hinge on the quantity found, or should intent matter more?
You know, and he knows this because I've told him this before. You're not the first person that has approached on me with this. You know? So, yeah, it's just, you got to understand that there's a lot that comes with this, right? If it was 1, perhaps, right? But you've got 3 in 3 different states. It's way too much. You know, at some point, it's got to stop. Now's that time. So, the idea is that has he made bond? He hasn't made bond on the cases upstairs, right? So, because you have not made bond, the 14 days here that would normally kick in is told if and until that hold upstairs is released. So if you're able to make bond on that theft case upstairs, that would kick in the 14 days for those states to come get you. And then they would have to battle it out as to who comes and whatnot, and, you know? So let's just let me know what you guys want to do. We can, the felony court is set for
Right now.
March 11th. Typically what we do is we just set it the day after. And I'm sorry, Mr. You know, it's just too much. Yeah.
Your Honor, I do also want to add, he hasn't waived on this new North Carolina case, so he wants to start that clock today.
Okay, I'll let you guys see if that's something that you want to do. You know, if not, we can go ahead and get a governor's warrant. That'll take 90 days. But, you know, if you post bond on the case upstairs, that would get the ball rolling really, really quick. So, okay. You guys let me know what you'd like to do. Thanks. Hi. Hey. Happy Friday, man.
Happy Friday. We are here.
Who do we have here?
We have Herman Riley, Judge, R-I-L-E-Y.
Good morning, Mr. Riley.
Requesting bond.
Okay, Mr. Riley, I've never met you before. I don't know you. I got to get to know you in the short time that we have here to see who are you? Are you a danger to our community? Well, everybody tells me that, right? Hold on. I know that you have a statement that you want to say, but what really matters is the paper, because that really tells me who you are. I get people that try to sell me the sun, everything here, but that really tells me who you are. So, Dave, let's get to know Mr. Riley.
Your Honor, he's wanted out of Louisiana for a domestic battery involving child endangerment and theft, but the theft is a misdemeanor, so he's only being extradited on the domestic. It was where he is alleged to have bitten his live-in girlfriend in front of a shared child and a second child, a 4-year-old and a 7-year-old. The warrant was issued on May of last year, so we're getting close to a year, Judge, for the
So he's been on the lam, you're saying, for a year?
Well, I don't believe it's an FTA. I believe it's a 2B warrant.
What's it to be? Okay.
I don't show any other history, and so state just requests that a sufficient bail be set, but I don't know of his ability to.
So you're okay with the bond?
I'm okay with a bond. I'm not okay with a low bond.
Judge, my client has requested that he address the court.
So let's not talk about the case, because you have the right to remain silent. Anything you say can and will be used against you. You got to understand that I have a ton of prosecutors here. Whatever you say, they're going to sit there, type it down. It's very possible it may get back to the prosecutors in Louisiana somehow. So don't talk about the case.
This is the official green light. Probable cause means the case moves forward, no turning back. And just like that, the judge lays down bond conditions. No alcohol, no drugs, no unprescribed meds. These are iron chains without bars. One slip, one mistake, and freedom disappears. Defendants call it a trap. Judges call it a test. Break the rules, and the gavel comes crashing down. My question to you, are bond conditions a fair chance to prove yourself, or just a setup designed to send people straight back to jail?
Myself.
My only concern is, if I set you a bond, number one, are you going to be a danger to our community? Number two, are you going to go back to Louisiana? Those are the main and primary concerns.
That's what I want to assure you of. Okay, right now I'm working. If I stay here 14 days, I may lose my job. I pay on child support and everything. I talked to the bondsman in New Orleans already. So as soon as I go up there, he gonna walk me out. I'm gonna take care of the bonding and everything. But I just want to let you.
It's set there.
I'm checking that right now, Judge. No, there's no bond set, which means they'll set one as the self.
So typically the way it works is if we set you a bond, we give you 14 days from the date of your release to go turn yourself into Louisiana. If you fail to go do that, you have to understand that there are serious consequences. I will revoke the bond, set it at 0, and I'm not going to give you another one. I don't care if you're kicking and screaming and Jesus told you to do something. I don't care. We give you one shot to go turn yourself into Louisiana. You understand?
Yes, sir.
Okay, so let's talk about a bond amount.
Your Honor, due to the offense and the fact that 2 minor children were present and the age of the warrant, is that state requests a bond of $7,500.
Judge, we'd request a bond set of $1,000.
Big difference.
It's a pretty big divide, Judge.
So the problem is also is that because you're a fugitive, right? You are an inherent flight risk. So the normal 10% that one would have to pay to typically bond out usually does not apply in fugitive cases, as far as I've been told. So you will probably have to pony up 100% of the money to be able to bond out on a fugitive case. So I guess speak with him, let me know, what's something that you guys.
He told me he could make $1,000 bond.
Yeah, I think 1,000 is too low.
That's the amount that he can make.
That's too low. I mean, that's what we do on normal cases, not just,
Unless I get new information, Your Honor, just again, due to the age of the warrant and the fact that there were minors present, is unless I get new information.
I don't want to keep you, right? But I have to make the bond sufficiently high so that I know that you're going to go back, right? What I'll do is I'll set your bond at $2,500, okay? And then just let me know, what we can do is, has he already waived or no?
No, he has not.
Have Abel reach out to your folks, your family, to see whether you guys can make it.
And under 2,500.
This is not I'm not going to negotiate with you, dude. It's just that 1,000 on a fugitive case with this type is just too low.
And also, just reminding the counsel and the court is that even presuming that he's able to make this, because Louisiana has set at no bond for him to return and go back to work, he has to make a secondary bond there. And if this is the maximum he is able to pay, then effectively he'll be held in Louisiana and he won't be able to return.
I'll also have to take that into consideration.
Judge, my client has chosen to not take the bond until, if that's okay with the court.
2,500,
Don't argue with it.
no, I'm not arguing. I just want
Here, look, let's do this.
I want to lose my job and everything.
Let's do this. I'll let you guys go back there, talk about what you can make. 1,000 is just too low, but I'm willing to work with you because.
And here's the hammer. Prosecutors ask for no bond at all. Translation: don't let this person leave. Don't give them the chance to walk free, even for a day. It's a brutal request because it strips away even the hope of fighting from the outside. Harsh, yes. But to prosecutors, this isn't punishment, it's protection. Protecting the public, protecting the system. And here's where the debate gets real. Should repeat offenders lose the privilege of bond, or does everyone, no matter how many mistakes, deserve at least one more shot at freedom while they wait for trial?
Really. But you guys, no, let's not do it here. Go back there, talk,
I'll stand down, Judge.
Christine?
Thank you, Judge.
Thank you, Dave. So Mr. Schreiber's on bond for a harassment case. He's now picked up a new case.
Yes, sir.
You now stand charged with the offense of assault of a family member. You are facing up to a year in jail and/or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, warrant will be appointed to you, sir.
On January 31st, 2025 in Harris County, Texas, officers responded to a family disturbance call. Upon arrival, officer met with the complaining witness, who stated that she and the defendant are married. Complaining witness stated that the defendant had arrived home drunk and that she hid alcohol from him, leading to an argument. The complaining witness stated that the defendant then grabbed her by her hair and pulled, causing pain.
Is this the same complaining witness in the harassment case?
No, Judge, this is going to be the defendant's wife. I've since spoken to her today in the back in the witness room.
Who is the
So
complaining
my
witness in the
understanding is
harassment?
that in the harassment, it's a neighbor, and then we now have the wife as the complainant.
Judge, if I may, then you may remember the old case. It involved a family that lived about 8/10 of a mile away and involved a dirt
I
bike.
don't remember anything.
And as a practical matter, no, it isn't a neighbor. It's a person who lives in the area. They don't, live next to each other. After this incident happened with the harassment case and his wife is here in court, Mr. Schreiber's now enrolled to go to a facility called Mallard Lake. It's a rehabilitation facility that addresses alcohol problems. He's going to be enrolling on Sunday. And they've sent the enrollment paperwork to my office yesterday. We are hoping that we can reset these cases to allow him to attend that. That is an inpatient program. We don't know how they anticipate it's going to be, not less than 14 days. But of course, it's one of those things they'll judge his success as he goes.
I am all for it. But you picked up a new case while you're on bond. I'm not going to let you go. I'm not going to give you any preferential treatment. You have to abide by all the rules, regulations as well. And when you pick up a new case, there are consequences. You're old enough to know that. You know, when you have actions, you take the wrong action. There are no mistakes in life. There are actions. And when you take the wrong actions, there are serious consequences. I'm now revoking your bond in the harassment case. You're staying with me. You know, now, hold on. I'm not done with you. I'm also ordering you now not to consume alcohol, illegal drugs, and I'm going to put a monitor on your ankle so I know that you're not consuming.
So I still would go to rehab, then we'll talk about that.
We'll work through all the, I guess, all the issues as far as there, but I'm not going to take your word for it that you're not going to consume. I need more concrete evidence, and the way that I do that are with these devices, you know, and you're now with me, absolutely no tolerance. If I find that you're now a further danger to my community, I'm going to go nuts on your bond. Do you understand? So what does wife want? Does she want to continue to have contact with him?
She is here to ask that the court modify the conditions of the magistrate order for emergency protection. Since this incident happened, Mr. Shriver's been living in a hotel.
And this is the climax. The judge takes control. Bond revoked. Ankle monitor ordered. It's not a suggestion. It's a sentence in itself. Why? Because Chad picked up a new charge while already out on bond. In legal terms, that's betrayal. That's breaking the court's trust. And once trust is broken, judges tighten the leash. An ankle monitor is more than technology. It's the court's way of saying, you'll earn our trust back one step at a time, if ever. So here's the final question. Do you believe strict surveillance is justice, or should second chances still exist after someone proves they can't be trusted?
They've abided strictly, even with their communication and transportation today, with the no contact. However, she is asking that we remove that restriction and instead go with the no threatening or harassing communication.
I've spoken with her and confirmed all of counsel's represented, and you know, we're not going to be unopposed. We're not going to be opposed to modifying it to no threatening or harassing.
So you have an order put in place by the magistrate. I'm leaving everything in that order intact except for one thing. Well, I guess two. Does the MOAP also say no contact as well?
It says no contact and don't go to their...
Got it. Okay, so I'm going to modify two things. The first thing I'm going to do is I will take off the residential restriction. Number two, I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case. You need to understand what is threatening or harassing doesn't matter what you think. I could give a rat's behind what you think. It's what she perceives. So if I go like this, is that threatening or harassing? It most certainly is, and it can land you in custody. And I'm going to tell you now, any more issues